Today, I'm going to be talking about two very important Supreme Court decisions having to do with Native issues and Native sovereignty. The first is a decision about Navajo water rights. So basically, the Navajo tribe, which has had a lack of clean running water for decades, they basically asked the federal government if they would assess and try to address the tribe's needs for water, both in the present and going forward, which seems like a very practical thing to ask, since the federal government has this fiduciary duty towards these reservations, towards these tribes, since they have forced them onto this land and restricted, their living in that way. So the Supreme Court basically said, no, there's no obligation here for us to assess your water access, your water rights. And, part of this has to do with the fact that water is going to become more and more scarce in the region. And the Colorado River is kind of already overpromised, like to so many different, farmers and so many different uses. So the Supreme Court did not want to give that that's kind of assurance, that security that yes, you are going to have this portion of this water going forward. Seems like fucking I don't anyway, so I'll let you guys respond to that quickly before I jump into the next case. But what do you think?
My first reaction to this case is like reading the opinions. It reminded me of the end of There Will Be Blood when Daniel Day-Lewis is like, drainage. I'll drink your milkshake from over here. And that's exactly what's happening here. Like by we, I mean the American government told them, you have to be here. We are going to take everywhere else. You be here. Don't have your traditional nomadic lifestyle. Be agritarian, whatever the word is, and live here. You'll have water to do that. And then we caused climate change and we used up the rest of the Colorado River, and suddenly there's not enough milkshake for them because we drank it from other places. And they're just like, hey guys, you kind of promised us this milkshake, and we're like, oh, you see, we didn't say that you could drink the milkshake. You could just have it, and if there's any left for you, then you can have some. Like, that's ridiculous. This is another one of those situations where it's like, if you were a kindergarten teacher settling a dispute between two kindergartners, you'd clearly think that, yeah, you promised them that you'd take care of them. If they lived here for you, you should take care of them. It's just very cut and dry to me.
Mm-hmm.
Okay.
Sorry. Go on, Desmond.
I mean, we've gotten a lot of John Cooper metaphors over the first 10 weeks of this show, but that one's going to be up there for sure. The Navajo Nation is an independent territory in a similar idea that the state of Colorado is, state of Utah, the state of Nevada, state of California. These were all different places that were supposed to be sharing the access of the Colorado River. Now, to guarantee water access for an individual state, but not to guarantee water access for the Navajo Nation's territory doesn't make consistent logic, in my mind. But then again, I think as we're going through, what did you call this earlier in the week, John? SCOTUS week, Shark week, something to that effect?
Yeah.
Yeah.
As we're kind of going across the different rulings of the Supreme Court over the course of this entire week, it does somehow seem consistent with how they seem to, cherry pick what is and what is not, fact, or what is and what is not just, or what is and what is not, the rights that people should have. Time and time again, we're seeing the rights of certain people just being infringed upon inconsistently, very, very, very inconsistently. And, in certain cases, more insidious than others. But I think, let's just be honest, we're talking about water right now. Like, what exactly are these people supposed to do? Like, what options have you left them with, especially in this part of the country? Arizona, New Mexico, like Colorado, Utah. I mean, these states are struggling right now. Meanwhile, they're also allowing things like golf courses to just waste so much water day in, day out. That's not being infringed upon. But no, this feels exceptionally insidious as far as the implications are concerned. It'd be one thing if they said, okay, we can't guarantee you X, but we'll guarantee you Y. But just to say that we're not going to guarantee anything at all.
Yeah. Yeah.
Erica, what was the word that you used earlier? Dark?
It's pretty dark. Yeah. Yeah. But it's not nearly as dark as some of the aspects of, I mean, I guess you can't really compare these things. It's all tragedies that have to do, very avoidable tragedies that have to do with the violence perpetuated by settler colonialism. And yeah, I don't know. Do you mind if I jump into this next case here?
Yeah, go ahead.
Okay. So about 3 weeks ago, the Supreme Court also made a decision about the Indian Child Welfare Act. And they surprisingly, this goes against all of the other decisions basically that we're going to be talking about today, they decided to uphold the Indian Child Welfare Act, it blows my mind. I am shocked by this ruling. So basically, the Indian Child Welfare Act was an act that was established because there were generations, decades of a policy of basically like forced removal of Indian children from their families, placing them with white families, which is part of the process of assimilation and the eradication of these tribes. If you slowly take these children away, which is the future of that tribe, and just kind of mix them in with the white population, they are going to lose their rights to everything that the federal government was supposed to provide for these Native people. So there's this scheme basically to dissolve the indigenous tribes, to dissolve the family units, and you do that through the adoption system. So there was very, very, very racist adoption policies put in place where, like 30 times more frequently, Native children would be put up for adoption than white children, because they would point to things like, oh, the grandmother is taking care of them, and this isn't a normal family structure, and oh, the kids were left in the elder kids were looking after the younger kids while the parents were out gathering whatever they need to do. Normal shit in these tribes. And the white settler, sorry, I'm spacing right now. The whole approach to child welfare is to like take these kids away. So basically, the court decided to keep this law in place to protect the right of these tribes to have priority in placement of Native children. So instead of like a child goes up for adoption, a Native child, the first placement that they're probably going to be given is a family member. If they can be placed with a family member, great. If they can't, another family in that tribe. And if they can't, then another Native family from a different tribe. And then after that, then white people get preference for adopting these Native children. But there have been multiple white couples who have, I think, been basically chosen by these law firms, these heavily funded, oil-funded law firms that basically have decided, we're going to find a few cases that have to do with, Native adoptions, and we are going to make sure that that the preference for these Native tribes gets destroyed. We're going to make sure that white people are going to get the preference there, and that is because the law firm here involved in this one case with one second, the Chad and Jennifer Brackeen, their case was taken on pro bono by Gibson Dunn and Crutcher. And
of course their names were Chad and Jennifer. Pick the whitest names.
But Desmond, you might recognize Gibson Dunn and Crutcher, that name. What have they been a part of? They're the law firm that has been harassing and persecuting basically Stephen Donziger for years and years for his fight against Chevron, because they're a Chevron law firm. Not only that, but Gibson Dunn was the law firm defending the sorry, I'm spacing here, but they with the ALU, they have been fighting the ALU. They're on behalf of Amazon, trying to crush that labor movement. They have also been involved in all of these other things. So they were also backing the oil pipeline at Standing Rock. And now they're finding these white couples, and they're trying to basically, help to pave the way for oil companies to go in with their pipelines and, have free reign on these reservation lands. But they can't do that if these reservation lands are still highly populated with Native people and thriving, and there's that Native, and especially youth Native resistance to these projects. So they decided, we're going to start targeting the young Native folks, and try to ensure that white people will get preference to take these kids away from their families, and further the project of racial assimilation and genocide that founded this country. It is that dark. It is that bleak. It blew my mind when I realized, oh shit, Gibson, Dunn, and Crutcher, they're involved with Chevron, Dunziger, with Standing Rock. They're involved at the Amazon Labor Union. It's just, so anyway, you guys want to respond to some of that?
Well, I think we should maybe do just an episode on that specific law firm one of these days. But the kind of my response to this is what a recurring theme now that I think we've discussed the last couple of weeks is a lot of times these conservatives, these right-wing organizations, they take a kernel of truth and they expand it to things that aren't true. And I think this ties in very nicely with what we are going to discuss about student loans, with what we discussed about affirmative action, in that there is a kernel of truth of, okay, there's a lot of bad things in preservations, right? A lot of drug abuse, a lot of, just not necessarily good things to raise a kid around. And so there is a reasonable argument to be made that, okay, well, we need to take these children off of the reservation for their own safety, right? And as long as they keep hammering that argument, they can get what they really want, which is what you're talking about, Erica, the destruction of the Native American community, of that tribe that is on the land that they want. Because they can, not be the moral bad guy if they're just trying to help the kids, right? But why? You have to ask that next why. You always have to ask the next why. Why is there rampant drug abuse on this native? Or why is this kid's parents dead? Or why is their XYZ problem that you're talking about with this specific tribe? And the answer is always the same people who are trying to fuck with the tribe now are trying to fuck with the tribe then. And we destroyed these what should be vibrant communities. And by we, I don't mean like us three, I mean the United States of America, the white settler colonialism from hundreds of years ago all the way up to right now with what they're fucking doing now. It is our fault, and therefore it is our responsibility to make sure that these tribes can stay intact and the children's welfare can be taken care of. Both can be done. It is not an either or thing. And that is the false dichotomy that this legal argument is essentially based on. And I'm very glad the Supreme Court saw it that way. I mean, I know it was more of a states' right issue when it came to the Supreme Court, but, from an ideological perspective, I'm glad that we are viewing it that way.
Mm-hmm. Desmond, any thoughts?
No, sorry, guys.
No.
Oh, no worries.
Yeah, I was just going to leave it right there. Unless, was there more?
I did want to add that this is just to make this even more bizarre. Amy Coney Barrett and Justice Neil Gorsuch both joined with liberal justices to uphold the Indian Child Welfare Act. And I learned, I didn't really realize this until a couple weeks ago, but Neil Gorsuch is the most well-read about Native issues of any of the Supreme Court justices. And he had an incredible opinion that he wrote, which was like, what the fuck is this shit? But he wrote about the mass removal of children from their family homes in the 1950s, 60s, and 70s. He wrote that that was only the latest iteration of a much older policy of removing Indian children from their families, one intentionally spearheaded by the federal officials with the aid of their state counterparts nearly 150 years ago. In all its many forms, the dissolution of the Indian family has had devastating effects on children and parents alike. It has also presented an existential threat to the continued vitality of the tribes, something that many federal and state officials over the years saw as a feature, not a flaw. In adopting the Indian Child Welfare Act to secure, Congress exercised its lawful authority, quote, to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. What? Like, he's so right, but I just never expected to hear it from him.
Broken clock.
Every once in a while, the justices can write a piece of poetry, and that's a good one.
Yeah, totally.